We've certainly heard a lot about some NFL cases in recent months. The first was the Aaron Hernandez murder trial, and more recently we've heard about Deflategate involving Tom Brady. With respect to the Brady issue, we have heard that the standard is preponderance of the evidence. And that strikes a lot of people who are Patriots fans, and I count myself among them, as unfair. But I take issue in terms of the standard that was applied. And I suppose I take issue with it because as a personal injury attorney, I'm accustomed to the standard of a preponderance of the evidence. Many people who've grown up watching TV and criminal trials think that a standard should be beyond a reasonable doubt. But that applies in the criminal context, whether it's the Boston Marathon bomber or whether it's Aaron Hernandez in the prosecution of his murder case. The reasonable doubt standard, I was always led to believe, is about a 90% or more satisfied by the trier of fact. However, a preponderance of the evidence means essentially almost what it sounds like, a little bit more. It could be about 51% if you want to quantify. And oftentimes in a plaintiff's personal injury case, I will argue that we have met the burden, or actually I will argue that every time that we have met the burden, but I will also add that the evidence is greatly skewed in the plaintiff's favor. And the fact that I'm explaining the standard of a preponderance of the evidence is not to be construed as saying my client is barely able to make out a case. That's certainly not something I would want the trier of fact to believe. Let me go on to a different issue with respect to the civil and criminal cases. In a civil case, there's really open discovery. Throughout the litigation, you can inquire of the defendant certain records and take the defendant's deposition and so on and so forth. And in a trial, you can even call the defendant as part of the plaintiff's case. Obviously, I'm sure you're aware, in a criminal case, it's altogether different. The prosecution could never call as a witness the criminal defendant. So there is a sense, really, accurately so, if I may say, that in a civil case, there's more of a wide open exchange. And the fact that as a plaintiff, that is as a person suing, you can call your adversary your defendant, or if you're suing a corporation, the representative of that corporation, that is a big advantage. Now, some people have said in the past, how could, taking another NFL case, O.J. Simpson, found not guilty by a jury in 1995, I believe, and yet 2 years later was found liable in a civil case. That goes back to the beginning of this blog, in which we can explain that seeming contradiction. He was found not guilty by a reasonable doubt standard, or by beyond a reasonable doubt, but he was found liable by a preponderance of the evidence. So there is really, one would say, no inconsistency between those verdicts. An interesting thing is what happens if he were found guilty. And if he were found guilty, that would be, as you have seen in earlier blogs that I've done, that would be collateral estoppel or res judicata on the civil case, such that the whole matter of his liability wouldn't even have to be tried in a second case. But the reality is that O.J. Simpson was found not guilty, and that did not preclude the pursuit of a civil case against him, largely or completely because of the preponderance of the evidence standard applying in civil cases, including personal injury matters. Thank you.